Welcome back to A Little Privacy Please. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Didomi. This is my weekly series covering what matters most in data privacy, and this week we have two updates, one in the United States and one from across the Atlantic. And together they reinforce a theme we've been tracking all year, the steady expansion of the privacy compliance landscape and growing pressure on companies to do more. Let's get into it. Starting in the U.S., Louisiana is on the verge of becoming the 23rd state to enact a comprehensive privacy law, and the third state to do so this year, following Oklahoma and Alabama. The bill has passed the legislature and is now awaiting the governor's signature. If signed, it takes effect January 1, 2027, and similar to what we saw in Alabama, there's a temporary cure period. Here, it runs through July 31, 2027, giving businesses a bit of a runway before enforcement goes fully live. Now, Louisiana isn't breaking any new ground in terms of content. Aside from a bespoke exemption for public opinion poll conductors, which is truly genuinely unique, there's no headline-grabbing provision that we haven't seen somewhere else. But what makes Louisiana worth paying attention to is the way it's been put together, which is following a trend. State legislatures have a lot of examples now to choose from when putting a comprehensive privacy law together. And rather than selecting one to adopt, they seem to be thinking of it as a build-your-own privacy buffet, where they can pick and choose the provisions they like best from each state. Louisiana appears to have adopted this approach. They drew provisions from multiple different state frameworks and assembled their own unique recipe. The bill tracks most closely to Texas, matching Texas on definitions, consumer rights, sensitive data requirements, and even some specific notice language. If you've done Texas compliance, a lot of this will look familiar. But it also borrows California's applicability threshold, and Oregon and Colorado definition of targeted advertising, Connecticut's approach to cure periods, and Virginia's decision to leave out some provisions that have become more common elsewhere, including universal opt-out mechanisms. So why does this matter? Because it's becoming harder to rely on the kind of compliance bucketing that privacy teams have historically used, picking a model and saying, if we're compliant here, we're mostly covered in the rest of the states in this bucket. As more states use this pick and mix approach, the differences between states are becoming more patchy and less bucketable. The practical takeaway, if you're already applying the most rigorous state requirements across your full U.S. footprint, Louisiana probably doesn't require anything new. But if you're taking a state-by-state approach, good luck with that. It's got to be getting very messy. You may want to seriously consider switching to a nationwide approach as this patchwork gets more and more complicated. Now let's turn to the UK, where the Information Commissioner's Office, the ICO, has issued a pointed statement on age assurance with one clear takeaway: more needs to be done. The ICO says it lacks confidence that companies are implementing adequate measures to prevent children from accessing services that aren't meant for them, and it names names. TikTok, Snapchat, Facebook, Instagram, YouTube, and X are all specifically called out as falling short, despite previous calls from the ICO to urgently strengthen their age assurance practices. The statement makes clear that the ICO is prepared to use its full enforcement toolkit, including formal investigations and sanctions. To understand what the ICO is actually requiring, it helps to look at the guidance it issued back in March, which spells this out in detail. The core principle is that if you operate a service that isn't suitable for children under a certain age, including if your own terms of service set a minimum age, then your obligation isn't just to have a policy, it's to actually prevent underage users from accessing the service. The guidance is explicit on why. If a child who isn't supposed to be on your service manages to access it anyway, you have no lawful basis for processing their personal data. So this isn't just a user safety question, it's a data protection compliance question. The guidance recommends effective age gates using technologies like facial age estimation, digital ID verification, or one-time photo matching, and it specifically discourages self-declaration, meaning letting users just type in a birth date, because it's too easy to circumvent. As we've seen in other jurisdictions, including in the US, regulators are placing a strong emphasis on protecting children. They want technical solutions, and they're prepared to enforce. For companies operating services in the UK specifically, or watching where global standards are heading, this is a signal worth taking seriously. So, two themes this week. In the US, the state-by-state expansion continues, and the compliance picture is getting more complex, not less, as each state adds its own twist to the model. And across the Atlantic, the ICO is raising the bar on age assurance and signaling they're done waiting for voluntary action. That's it for this week. For the full analysis, check out our newsletter, A Little Privacy Please. I'm Julie Rubash. Thanks for joining me, and until next time, go enjoy a little privacy, please.